The Supreme Court issues 9-0 unanimous decision changing Second Amendment and Fourth Amendment fight. The silent quake beneath the Constitution. It didn't make front-page headlines, no breaking news ticker. No presidential statement. Yet inside the marble halls of the United States Supreme Court, a silent earthquake just struck the Constitution. In a rare moment of total unity, every justice, liberal, conservative, and moderate, voted the same way, 9-0. A complete sweep. And while the decision never once mentioned the Second Amendment, its impact is destined to reshape it. Because if you carry a firearm, keep one for defense, or simply believe that freedom means something more than government permission, this ruling changes the rules of engagement forever. Before we break this down, subscribe to the Firearms Legal Desk. We uncover the court rulings, bills, and backdoor policies that directly affect lawful gun owners. Knowledge is defense. Ignorance is surrender. Hit subscribe. Let's get into Barnes versus Felix, the case nobody saw coming. Chapter 1. The case that started like any other. It began as a routine traffic stop, one of those daily encounters between citizen and state that most of us never think twice about. Officer Robert Felix Jr. pulled over Ashton Barnes, a young man suspected of minor violations. Nothing dramatic. But the encounter escalated in seconds. The officer asked Barnes to exit the vehicle. Barnes opened the door, stepped halfway out, then suddenly tried to drive away. Acting on instinct, Felix jumped onto the moving car's door ledge and fired twice. 2 bullets. 5 seconds. A life ended. Barnes's mother sued, claiming her son's Fourth Amendment right to be free from unreasonable seizures had been violated. The legal question: was the officer justified in using deadly force at that instant of perceived threat? Or should courts consider the entire sequence that led to that moment? Chapter 2. The Moment of Threat Doctrine. For decades, courts, especially the Fifth Circuit, used a narrow lens called the moment of threat rule. Under this rule, judges examined only the brief instant when force occurred. The officer feared for safety in that split second. The shooting was justified, period. Both the district court and the appellate court sided with Officer Felix, who was clinging to a moving car. They said deadly force was reasonable. Case closed. But here's the problem. Context vanished. What caused Felix to end up on the door ledge? Could the situation have been de-escalated? Was Barnes actually a threat, or simply misunderstood? Those questions were off limits. And so, time and again, citizens, including lawful gun owners, lost their constitutional shield because judges looked only at the gunfire, not the buildup. Chapter 3. The tension builds. The moment of threat doctrine became a silent permission slip. As long as an officer could describe a flash of fear, courts rarely looked further. That meant lawful carriers, people doing everything right, could still end up in a fatal misunderstanding with almost no legal recourse afterward. A holstered firearm, a declaration of "I'm carrying legally," or even a nervous movement could be seen as threat enough. The aftermath. Always judged in isolation. But the Supreme Court was about to change the frame entirely. Chapter 4. A unanimous shockwave. In a decision written by Justice Elena Kagan, the court dismantled the doctrine. The Fourth Amendment requires an inquiry into the totality of the circumstances, Kagan wrote. No longer could courts freeze the story at a single second of fear. They must consider everything. What the officer did before, how the suspect behaved, whether alternative choices were available, and whether escalation was avoidable. The opinion declared that context is constitutionally required. This wasn't a minor fix, it was a paradigm shift. And for every armed citizen, it redefined what reasonable force now means. Chapter 5. Why gun owners should care. You might ask, what does a police shooting case have to do with the Second Amendment? Everything. More and more lawful gun owners find themselves in tense encounters, traffic stops, red flag checks, mistaken identity calls. Until now, if an officer fired under misunderstanding, courts often excused it. But with Barnes versus Felix, the High Court announced, "We will look at the entire picture." That means if you were acting lawfully, if your firearm was holstered, if you announced you were carrying, the court must now weigh those facts, not ignore them. The Second and Fourth Amendments are no longer strangers. 1 guards your right to carry. The other guards you from being harmed because you exercised it. Together, they now form a stronger constitutional shield. Chapter 6. A new legal framework. The court didn't just remove an old rule. It built a new one grounded in fairness and accountability. Judges must now examine The full timeline, from first contact to final action.
The officer's decisions leading up to the event. Opportunities for de-escalation that were ignored or mishandled. Objective reasonableness from the viewpoint of a trained officer. Not emotion, not hindsight. 1. This totality of circumstances test creates balance. T protects good officers acting under real threat while holding bad judgments accountable. For lawful gun owners, it means the courts will finally see the whole story, not a single frozen frame. Chapter 7. Repercussions across the nation. This ruling doesn't stay in Washington. It now ripples through every federal circuit. Lower courts must revisit pending excessive force cases. Appeals once dismissed under the narrow rule may return. State policies and police training programs will have to adjust. In legal circles, attorneys are already calling this decision the Miranda of use of force law. It forces every department to acknowledge that constitutional rights do not vanish in moments of panic. For decades, some circuits shielded officers by default. Now, accountability has constitutional teeth. Chapter 8. Reality check for gun owners. Here's the uncomfortable truth. As a gun owner, you're statistically more likely to interact with law enforcement, whether at a traffic stop, range inspection, or community complaint. What happens in those first few seconds can decide your future. Barnes versus Felix gives you new legal ground. A T means if an encounter goes wrong, your attorney can argue not just about a snapshot of fear, but about the entire chain of events. Judges must now ask, did the officer misread a legal act? Was the citizen calm and compliant? Did escalation begin because of poor tactics? This doesn't make all uses of force illegal, but it raises the bar for justification. And it finally makes room for your side of the story to matter. Chapter 9. The Convergence of Rights. For years, scholars treated the Second and Fourth Amendments as separate realms. One about owning arms, the other about searches and seizures. But freedom is indivisible. The right to carry means little if the state can harm you for exercising it. The right to be free from unreasonable seizure means less if self-defense can be twisted into suspicion. This decision fuses those protections. The court effectively said, carrying a firearm lawfully cannot, by itself, justify lethal force or suspicion. That recognition marks the start of a constitutional convergence, a reaffirmation that your rights travel with you, holstered or not. Chapter 10. The Road Ahead. Already, law enforcement trainers are rewriting policies. Officers must now consider how their actions before a shooting will be judged. Municipalities could face new lawsuits. Civil rights attorneys are preparing arguments grounded in Barnes v. Felix. And citizens who were once ignored are finally being heard. But the deeper message of the 9-0 ruling is this: rights are not partisan. When 9 justices agree, across the widest ideological divide, that constitutional protections must include context, the system itself takes a breath of integrity. Chapter 11. What it means for all of us. You don't have to follow court transcripts or legal journals to feel this shift. T affects every stop, every knock on a door, every lawful citizen carrying responsibly. This decision is a reminder that freedom is fragile only when we forget it exists. So the next time you hear about a court case that seems small or technical, remember Barnes v. Felix. Because it proves that even quiet rulings can redefine the boundaries of power. This ruling won't trend on social media, but it should. It's a declaration that your rights don't stop at a traffic light or a doorstep. They travel with you, protected by the Constitution, reaffirmed by 9 justices who saw past politics. If you've ever wondered whether the system still works, whether anyone in Washington remembers the meaning of liberty, now you know. The Supreme Court just reminded the entire nation that context matters, truth matters, and constitutional rights are not convenient, they're commanding. Share this video. Let other lawful gun owners know the rules have changed. Drop a comment. Does this decision make you feel more protected or more cautious? And if you want straight, factual, courtroom-tested insight into every major case shaping your rights, subscribe to the Firearms Legal Desk. Stay informed. Stay lawful. Stay free.